There's been a lot of changes to Charlotte zoning that has really changed the investment thesis for a lot of investors looking at Charlotte, or just people, everyday folks, mom and pop investors, maybe you, that are looking for the next place to call home for at least a while before renting something out. And so I'm going to talk through specifically the 2023 change that Charlotte made that eliminated single family only zoning citywide, countywide. And the intent that the city stated was to fix affordability. But the biggest impact of this was that it created a massive investment opportunity. And so we're going to talk about what actually happened to the value of dirt, the impact it has on housing, and answer a few different questions here. So the questions that we're going to be answering today: what can you actually build on a Charlotte lot today? What is legal to build in terms of subdividing for duplexes and triplexes? How do you figure out what the lot will actually digest in terms of multiple units? Where are some of the areas and types of lots that we're seeing where the math pencils out? What if you're not a builder? What can you do to take advantage of this? And what are the criteria that kill this for being an opportunity in general? So let's talk through what you can actually build right now and go through a little bit of the backstory of this. So just to introduce what we're talking about. So this is the official City of Charlotte Unified Development Ordinance. And what this document does in 647 pages and some dense reading, what it does is it outlines a single new system for how to allow for small multifamily properties and be able to create sublots, so you can even sell off 3 individual units on what used to be a single parcel. And so if we go down to 4.1, this is the meat and potatoes, the most important part of this, especially as it relates to single-family zoning. So the Neighborhood 1 zoning districts respects the character and development patterns of Charlotte's established residential neighborhoods and promote new residential neighborhood development in a manner that implements the city's vision for the future. The N1A through N1E zoning districts allow for the development of single-family, duplex, and triplex dwellings on all lots. And additionally, quadruplex dwellings are allowed on arterial streets in these zoning districts when an affordable housing unit is provided within the dwelling. And so what this does is it allows for any residential zoning. It allows us to be able to develop multiple lots on, or sublots, on that parcel. The entitlement's already here. You are not asking anybody for permission. There is no rezoning, no hearing, no neighbor vote, and conditional rezoning can easily eat 9 to 18 months plus a public meeting. But here you have it by right, and you don't really have to do anything else other than just submit plans and the city will approve it. So the ordinance itself, again, the purpose is to allow for the development of single-family, duplex, and triplex dwellings on all lots, and additionally, fourplex dwellings as well are allowed on arterial streets when an affordable housing unit is provided within the dwelling. There was a rule that was proposed by staff in March of 2024, but was never adopted, to make triplexes on corner lots only. And that's important to also understand, because I've seen some blogs that looked suspiciously AI written that said that that was now a rule as well, but this, according to this, that is not showing it. And this is the actual updated March 2026 version of the UDO. Now, a few things when you're looking at a lot to understand if it is eligible for UDO. Depending, what you're going to do is look for this table 4-1, and look at the lot standards. Now, this is a point of confusion I've run into when I was going over this with a client recently, and I just wanted to clarify. So table 4-1 is the lot standard that is used for determining if a lot is eligible for UDO. However, table 4.2 is talking about building siting standards And so what that is referencing is if you have a lot that you are then subdividing, what are the setbacks and things you need to be mindful of in order to get those sublots approved? This is an important differentiation because this is where you're looking at the lot to be subdivided or to be building on, and then this is where you're looking at how you're building multiple units on that property. So to give this some legs and really make this a little bit more concrete, I can't share specifics because I'm actually going to do a showing later this afternoon with a client of mine, good friend of mine that's a general contractor, because I found a property that should be eligible for UDO and would present a really good opportunity for developing a 2-unit property, a duet on it, that would be great for, great new construction opportunity, because that's in line with his investment thesis, and that's what he's looking for. So this 2-unit property that we're looking at is a little over 1/3 of an acre. It is zoned N1B. And so what you can see here is, and if we do some quick math, so an acre is 43,560 square feet. If I can get this, 43,560 square feet times 0.33, it's about 14,000 square feet. So as you can see here, that is more than 8,000. So this is eligible for UDO. The minimum lot width, it has a width of like 65 feet. So it's exactly what it needs to be. It is also the maximum building coverage, lots of 10,000 square feet and greater, 40%. So that means that out of this, we can cover no more than 5,700 square feet, roughly. So a few of the constraints that are important to understand here: 20-foot sidewall cap on duplexes, triplexes, plus a 45-degree building height plane above it. You can only exceed 20 feet if the average facing sidewall of the buildings, let's see if I can find this, average facing sidewall of the buildings on both sides exceeds it, and you have to submit a sidewall height survey to prove it. This is intended to prevent just having big monster houses that kill the existing character of the neighborhood. And it's also the single biggest thing that kills triplex pro formas if you are trying to just build up, just for the sake of building up. There's also 1.5 spaces per unit on duplex, triplex, or fourplexes. Triplex needs 5 spaces. And planning director Allison Craig said that they want 3 driveways, 3 2-car garages, and you end up with mostly pavement, because they would ideally like to get as many cars off the street as possible. Let's see, block face setback. Where was that article actually? We are hoping for more duplexes, Allison Craig said. With triplexes, it's challenging with the driveway cuts because they want 3 driveways, 3 2-car garages, and you end up with mostly pavement. It's hard to manage for a tree-lined street. Craig says by having triplexes on corner lots, there's more room for driveways and entrances for these homes. I believe this is referencing the rule that ended up never actually getting passed. Tree save exemptions. Charlotte's tree canopy is one of the city's most valuable natural resources, improving air quality, supporting neighborhoods, and enhancing quality of life, which is true. I absolutely love the trees here. It's very rare. Through range programs initiative, the city works to preserve, protect, and expand the urban forest for future generations. Our tree canopy programs highlight efforts related to policy and long-term planning, land conservation, resident tree care assistance, and recognition of community tree advocates. From implementing the tree canopy action plan to celebrating stewardship through yada, yada, yada. So this is real important too. I have a friend that is developing a duplex right now, and with the tax fees and stuff to remove 2 trees and then the cost of removal, it was like 20 grand to remove 2 trees. And so this is also very important to understand as part of the UDO. Tree canopy action plan establishes Charlotte's long-term strategy to preserve, restore, and expand the city's urban tree canopy as growth continues. Led by the City of Charlotte's Department of Planning, Design, and Development, the initiative will align with the Charlotte Future 2040 Comprehensive Plan to support a healthier, more connected city. Heritage trees 30 inches or greater will not qualify for removal unless there's an arborist report concluding that the item should be exempt from heritage tree protection measures. I think it was, in his instance, it was specifically two heritage trees, like large 30-inch diameter trees. I do know that you have to commit to replanting no matter what, pretty much, which again is a good thing long term. Going back to the core of this, so that's a quick overview of how to determine if this is an eligible lot or, something that would be a good candidate for being able to create sublots from. But there are exemptions that you need to be aware of in order to know whether or not it even is something that you could apply the UDO to. So there are 3 different layers of restrictions on whether or not you could subdivide. And so if you've heard CC&Rs for, the newer investors or people newer to real estate, just a real quick lesson here. Covenants, codes, and restrictions. So covenants are part of an HOA, an association. Codes are part of the city, and then restrictions run with the deed. So it's on the deed. If you are looking at whether or not something is eligible, so the biggest restriction that was lifted as a result of this, let me just real quick add this here. So as you can see here, and you can go and look this site up. This is explore.charlottenc.gov. This is especially if you are newer to Charlotte or newer to investing and you're looking at Charlotte. This is the single greatest, even if you're not investing. If you're just trying to explore the city, you moved here recently, you're coming here soon, like this is the single greatest tool that you will find. Trust me. I've been doing this for years, almost half a decade. Actually, a little over half a decade. So I just added on here the data for zoning, and now you can see for any address, which I could search an address on here too, but just, we're looking through the neighborhoods, you can see this is N1B, N2B, N1C, N1D, and then if you're looking at the UDO, let's say we're looking at N1-C. Now you can go and look up, and also you can see the previous conventional zoning district. So this is also an important distinction to make. Prior to the UDO, there's a different convention that was being used, and so you will still see the old zoning districts on paperwork and on records sometimes, and it can be very confusing. Especially when you're like, well, what's the difference between R3 and N1A? There is no difference. They are the same thing. It's like the Michael Scott meme. Corporate needs you to find the difference between these 2 pictures. It's that, but it's R3 and N1A. Anyways. So now, as long as it was a residential zoning, so N1A through N1E, any of those are now eligible for UDO, and there are still 2 other types of restrictions. So there is still the covenants, so if there's HOAs, and then also restrictions that run with the deed. However, for both of these, there are exceptions that, particularly due to some cases recently, or a couple of years ago, have some far-reaching implications that are also we're starting to see the impact of. Now, I will put on this, just for everybody, remember, I'm not an attorney. I'm not a lawyer. I do not pretend to be such. I'm a great licensed real estate broker here in the city. However, I do not pretend to be a lawyer or anything else because I am not. So consult with your legal counsel before taking anything that could be construed as legal advice or otherwise. Anything basically that I'm not licensed for, consult with the appropriate professional. Please and thank you. This is an opinion piece, and mind you, this is from August of 2023, which was right after this came out. But it still is interesting because it touched on a couple of things that we're talking about here. According to Alexandria Sands, which also since then there has been a ton of this, so again, outdated. 7 building permits filed in June and July. 20 new construction for duplexes in June and July of last year, and 29 in 2021. Could be a few reasons duplex construction rate didn't increase. Construction costs and interest rates remain relatively high. Architects and designers are still figuring out the new rules. Deed restrictions and homeowners associations are regulating multifamily housing. Higher density housing makes the most sense in South Charlotte, where land values are higher, land use and zoning attorney Colin Brown tells Axios, but that's the part of the city where deed restrictions are more likely to prohibit multifamily housing. That said, also, anywhere the land is cheap enough to build it will make sense. Obviously, more expensive areas, when there's an opportunity like this, are generally where the most margin can be, and so it is also where a lot of people will flock to. That's going to put the pressure. So 67% of single family lots in Charlotte are under homeowners associations. So many of those are in South Charlotte. Data from the city shows, and 95% of those associations prohibit types of housing other than single family. That's going to put pressure on some of the crescent neighborhoods that may or may not have deed restrictions, as they may not have HOAs that are active or funded well enough, Brown says. HOAs would need to hire a lawyer to privately enforce their regulations. Of the 7 construction permits filed, 1 was in Sedgefield and another was in Myers Park. The others were scattered throughout the city. And also important, the North Carolina Supreme Court recently ruled that certain deed restrictions excluding multifamily homes are no longer valid. The case stemmed from a lawsuit over a property line in Charlotte's historic Eastover neighborhood. The original developer placed a no apartment house rule in the 1920s deed restrictions. It remains to be seen what impact this ruling will have on neighborhoods like Dilworth and Myers Park. And this is actually something we're going to get to here in a little bit, but I wanted to just touch on that before we also bring up, let's see, where's the 2040 plan? CharlotteFuture2040plan.com. Charlotte will strive for all neighborhoods to have a diversity of housing options by increasing the presence of middle density housing. So duplexes, triplexes, fourplexes, townhomes, and ADUs, and other small lot housing types, and ensuring land use regulations allow for flexibility and creation of housing within neighborhoods. Objectives: increase the overall access to housing opportunity equity metrics index for the city, increase the number of ADUs in existing and new neighborhoods, increase the number of middle density units such as duplexes and triplexes in all neighborhoods, increase the number of middle density housing options, including fourplexes along high performance transit and other major thoroughfares. Increase the number of middle density housing units options in transition areas between low intensity neighborhoods and higher intensity place types. Increase the number of residential dwelling units with less than 1 parking space per unit. And increase the number of small footprint housing units in existing and new neighborhoods. So basically, a big chunk of their goals are to increase the density of neighborhoods, particularly around transit options, which from a city planning perspective makes a lot of sense, because if you're investing in mass transit, you want to make sure that you are building and incentivize building that people will actually use that around it, because otherwise, why are you investing the money in the first place? New zoning and entitlements included in the UDO would not change any codes, covenants, and restrictions associated with HOAs. So basically, it doesn't supersede the HOA. However, you cannot have an HOA that's formed after the UDO or an amendment to the covenants of an HOA after the UDO that would then make it to where you could subdivide within an HOA, and so that still is not possible. It will not be possible. And there are actually 3 ways that a neighborhood could opt out. So if they already had the existing HOA covenant prior to, which supposedly would be about 2/3 of lots, neighborhood character overlay, a neighborhood can apply for one, or a historic district designation. And Elizabeth, I believe in that, if I'm seeing my notes correctly, was talking about pursuing this specifically as a UDO shield. So in order to find the lots that are in fact eligible for this, the easiest way is to just first make sure there's not an HOA or some sort of covenant on the lot. But there is also the question, even if it has a covenant, is the covenant still enforceable? So if we go to the Charlotte Explorer here, again, you can look up the actual zoning and see whether or not, because if it's not zoned correctly, you would have to rezone. So it could be N1A through N1E, any of those. Then we would want to go to the deed lookup, which if you just search like Mecklenburg County deed lookup, you can find it that way. And then access online database. And then click here to acknowledge disclaimers out of the site. And then the easiest way to do this, in my opinion, is to just search for I'm not sure if I'm thinking of the right county. One of the counties, the property ID number was by far the easiest, but I don't think it was Mac. We'll go through an example property here. Let's just pick a random one here. So this is N1B, and I believe that would be the PID right there. Yep, okay. 4412 Summerdale. And then we'll go to Polaris. Yeah, so that is the PID. So 1010-4301, which then is also reflected here, 1010-4301. And then we already got the zoning information. Here you go. So this is what you can then do is see here is the deed from, in Polaris, it'll let you link directly to the document. It really is insane like how much data is out there, but navigating it, again, I did this a lot and I still get lost sometimes because there's just so much to it. Being all in lot 6 in block 5 of Robin Hood Woods, section 2, as same as shown on map thereof recorded in map book 12, page 359. And there's an easement on here too. Permanent utility easement. It looks like it'd be right there. Yeah, because that's the wedge in Summerdale. It should be like the right-hand side of the wedge. Yeah, so it'd be right here, would be that easement. Oh, that's interesting, because that would also be under the driveway. That sucks. Learn something new every day. Again, it's an example property. So, looking for recorded declaration of covenants, conditions, or restrictions referenced in the deed, which I see on here. Yeah, I see this. I did not see, however, anything else related to this. To have to hold that aforesaid lot or parcel of land and all privileges appurtenances thereto belonging to the grantee in fee simple grantor covenants and the grantor covenants with the grantee that grantor is seized of the premises and fees has the right to convey same in fee simple. Title is marketable and free and clear of all encumbrances, and that grantor will warrant and defend the title against lawful claims of all persons whomsoever, other than the following exceptions, any and all valid and enforceable restrictions, conditions, covenants, easements, or right-of-way appearing in the public record. Let's see, so Robin Hood Woods, no records found. Deed restrictions. Loan was made pursuant to the U.S. Department of Housing and Urban Development Home Program. So this is probably just something related to when they used that 5 years. Yeah, it's basically like, especially for a lot of grant programs, it's basically just saying that you agree to pay stuff back, and then also generally that you can only sell the property to somebody that makes some percentage of the median income. Property may only be used as principal residence of the borrower. Property is sold, transferred, or conveyed. The owner shall be responsible for repaying the lender the entire amount of the loan or a prorated portion subject to the terms of the loan as provided for. Owner shall submit any information, documents, or certifications requested by the City of Charlotte, which the City of Charlotte shall deem reasonably necessary to substantiate the owner's continuing compliance with the program. But I don't see anything that, so it's, I guess, good and interesting that we see stuff popping up, but is not, now granted, if this is an old neighborhood, which it looks like it would be, I'm not sure if anything prior to 1990 will show up. We're about to get super old school with this. So we go back to the oldest listed deed, 1994. Property here and above described was acquired by grantor by instrument recorded in deed book 6202 at page 325 of said registry. Deed book 6202, page 325. This was 101-04301, January 1990. Map book 12, page 359. This was 1965. Do hereby certify. Surveyor personally appeared before me this day and acknowledged the due execution of the foregoing certificate. Swore to the truth of the statements set forth wherein. I also wonder, did they handwrite all this stuff too? Like, is this just somebody's handwriting? Because it's real good. I'm impressed. Anyways, I digress. We're going to figure out, because I've figured out how to do this in Gaston County before, and I've done it before in Mac, but I can't remember how exactly. Search the recorder's database for the original plat map. Okay. Covenants are very frequently written directly onto the margin of the master map, so the map will list the exact document number where the subdivision's master rules are recorded. Yeah, I'm not seeing any other documents referenced. So again, not a legal opinion, and I would get title work done, but this is fairly certain that there is nothing here and there's nothing hidden in the history. Fairly certain there's no deed restrictions or covenants. So no HOA, no covenants, and because this was really just like the preface. I got on a tangent, but this is the preface for one particular instance where residents say deed restrictions prevent triplex in South Charlotte neighborhood. Residents of a neighborhood in South Charlotte are suing to block a developer from building a triplex. It looks like it's the first such lawsuit since new building regulations allowing duplexes and triplexes in most single-family neighborhoods took effect last year.
It's Morning Edition on 90.7 WFAE and WFAE.org. I'm Marshall Terry. Residents of a neighborhood in South Charlotte are suing to block a developer from building a triplex. It looks like it's the first such lawsuit since new building regulations allowing duplexes and triplexes in most single-family neighborhoods took effect last year. Tony Messia of the Charlotte Ledger Business Newsletter joins me now for our segment, Bizworthy. So you report in the Ledger this week, this is in the Lansdowne neighborhood. Just what is the project in question, and what's the argument residents make against it?
Developer Aspen City Homes bought a lot last year for $750,000, wants to put 3 housing units on that property. Neighbors are opposed to that. They say they worry about the effect on traffic, and they say that deed restrictions on neighborhood lots prohibit any structures besides single-family homes. So they have filed suit to try to block that. I reached out to the developer and the developer's attorney. I did not hear back, but they say in court documents that they believe those deed restrictions are unenforceable because they expired a few decades ago.
Well, oftentimes deeds are decades old and maybe only sporadically enforced. So are they enforceable here?
Well, the court's going to have to look at that. A lot of Charlotte neighborhoods, especially older neighborhoods, do have these deed restrictions that are decades old that are supposed to run with the property, or maybe they expire after 30 years. The issue, without getting too technical, is a lot of times if they are not passed along in that chain of title when the house is sold, they become unenforceable under state law. So it's really a question of, did these deed restrictions in Lansdowne expire in 1989, as the developer said, or were they restated and renewed around that time, as the residents are saying? So that's something the court's going to have to look at.
What are other neighborhoods doing as duplexes and triplexes pop up?
There are a number of neighborhoods that are looking at how do you impose deed restrictions on a neighborhood or reimpose them if they were there and had previously expired. It's a little bit under the radar. Neighborhoods often don't like to signal to developers that their neighborhood might be ripe to build triplexes in. You have that going on. At the same time, you have a couple other neighborhoods. You have Myers Park and Eastover, we've reported, that have hired a lobbyist to try to change state law to try to reimpose some of these deed restrictions. Because if there are deed restrictions on a house that prohibit duplexes and triplexes, that sort of supersedes the city's new development rules, and is sort of a way to prevent some of these higher density developments going into neighborhoods.
Well, let's move on now to a story we talked about last week, and that is the higher tax bill people likely face if they've been placing online sports bets in North Carolina now that it's legal.
All right, let's see if we can pull up this actual lawsuit. Oh wait, I already had it up. Cool. Supreme Court. So this was C Investments 2 LLC versus Auger, and I believe this was, I don't know if it was the same one or a similar one. This particular case was talking about a 1955 subdivision that did not have an HOA, but there were restrictions that got thrown out by the court. In this case, we're called upon to determine the proper interpretation of, let's download this so we can actually open it and read it properly. 13th enumerated exception, defendant's appeal from a divided Court of Appeals decision. Our review of the matter concerns whether the Court of Appeals correctly determined that the Act's 13th exception did not apply to save all of the 9 restrictive covenants. By applying this Court's well-established principles of statutory construction affording the legislature's plain unambiguous, we conclude that the 8 covenants at issue do not fall within the scope of the Act's exceptions and are therefore extinguished by operation of law. Accordingly, we affirm the opinion of the Court of Appeals. Country Colony, so this is a different instance, different case. Country Colony is a residential subdivision located in Mecklenburg County, which was developed by husband and wife Henry G. and Miriam C. Newson in the 1950s. On 25th February 1952, prior to selling any parcels within Country Colony, the Newsons recorded 9 restrictive covenants at the Mecklenburg County Register of Deeds, which were intended to govern the subsequent development of the subdivision. These covenants were recorded in Book 1537 at page 517 and specified that they were to run with the land and remain binding on any and all subsequent parties and persons. The Newsons further provided that any lot owner within Country Colony could enforce the restrictions through proceedings at law or in equity against any other property owner in violation thereof. The covenant requires that 1. All lots in the tract shall be known and described and used for residential lots only. 2. No structure shall be erected, altered, placed, or permitted to remain on any residential building plot other than one detached single-family dwelling not to exceed 2.5 stories in height and a private garage and other outbuildings incidental to residential use of the plot. No building shall be erected on any residential building plot nearer than 100 feet to the front lot line, nor nearer than 20 feet to any sideline. No noxious or offensive trade or activity shall be carried on upon any lot, nor shall anything be done thereon which may be or become an annoyance or nuisance to the neighborhood. No trailer, basement, tent, shack, garage, barn, or other outbuilding erected in the tract shall be at any time be used as a residence temporarily or permanently, nor shall any structure of temporary character be used as a residence. No dwelling costing less than $10,000. That's very different times. Be permitted on any lot in the tract. The ground floor area of the main structure, exclusive of 1-story open porches and open carports, shall be not less than 1,200 square feet in case of a 1-story structure. In the case of 1.5, 2, or 2.5, ground floor area of the main structure, exclusive of 1-story open porches or carports, shall not be less than 900 square feet. It being the intention to require in each instance the erection of such a dwelling would have costs not less than the minimum cost provided if same had been erected in January 1952. A right-of-way is and shall be reserved along the rear of each lot and along the sideline of each lot where necessary for pole lines, pipes, conduits for use in connection with supplying public utilities. In the event of the unintentional violation of any of the building line restrictions herein set forth, parties shall reserve the right by and with mutual written consent of the owner or owners for the time being of such lot to change the building line restrictions set forth in this instrument, provided, however, that such change shall not exceed 10% of the original requirements of such building line restrictions. 9. None of the lots shown on the plat shall be subdivided to contain less than 2 acres and only 1 residence shall be erected on each of the lots. Plaintiff is a North Carolina LLC who owns 7 parcels within Country Colony, which it purchased between 2016 and 2017. Each parcel has a root title more than 30 years old that either entirely fails to mention or does not specifically raise by reference to book and page or record the aforementioned restrictive covenants. Neither is such information provided by any deed subsequently contained within the chain of title. Requesting declaratory relief regarding validity and enforceability of the above covenants, plaintiff argued many of the covenants as applied to the plaintiff's lots are invalid under the North Carolina Real Property Marketable Title Act, which provides that any conflicting claims placed upon one's title to real property shall be extinguished if not recorded within the chain of record title going back 30 years. Oh, interesting. I forgot. I have heard that before. So if it's not in the last 30 years, which we can see in the subject to certain exceptions, then it should be good. 2 named defendants, Lawrence and Laura Tillman, who sought to sell their own property within Country Colony for development, filed an answer counterclaim against plaintiff and cross claims against all other defendants seeking identical relief. I don't know what that means, I'll be real. Again, not an attorney and not a lawyer. In no way a legal professional. However, I am a professional who is legal to practice real estate. Lauren Heaney submitted her own answers to the complaint and cross-claim. Plaintiff filed a motion for leave to amend its complaint, followed by an amended complaint in order to join additional parties, properly identifying the owners of a lot and further claiming its argument relating to the Marketable Title Act. Tillman's likewise amended their answer, counterclaim, and cross-claim. Following this, the Rawbachers and the Auger defendants filed updated answers to plaintiff's amended complaint, as well as the Tillman's amended cross-claim between. So this was a whole mess of neighborhood drama. Anywho, on 20 December 20th, filed a motion for summary judgment. Plaintiff and the Tillmans filed opposing motions for summary judgment, requesting the trial court find that they held marketable title free and clear of all the nuisance covenants under the operative provision of the Marketable Title Act. In support of their motions, plaintiff and Tillmans each filed certified copies of their deeds establishing chain of title going back more than 30 years and without reference to the nuisance covenants. The Auger defendants submitted a memorandum in opposition to the plaintiffs and Tillman's motions on 31st January 2019, arguing that the nuisance covenants were validly created and not terminated by operation of the Marketable Title Act. On 8th April 2019, the trial court entered an order granting plaintiffs and Tillman defendants motions for summary judgment, finding that the act operated to extinguish all but the first of the nuisance restrictive covenants as applied to the plaintiff and Tillman's property. Trial court found that none of the Act's 13 enumerated exceptions applied to preserve these covenants, except for the first covenant, which restricted the subject property to use for residential lots only. I want to know why that one specifically, though. Covenants applicable to a general or uniform scheme of development which restrict the property to residential use only did not additionally shield covenants 2 through 9 from the extinguishment provisions of the Act, and the Court of Appeals affirmed the trial court's grant of summary judgment. The question before this court is which, if any, other restricted covenants fall within the purview of NCGS 47B313 and are thus shielded from the extinguishment provisions of the Real Property Marketable Title Act. After careful consideration of the Act's plain words and legislative history, as well as our own precedent interpreting substantially identical language, we conclude that only the first of the 9 covenants at issue survives operation of the Act. We therefore affirm the decision of the Court of Appeals. We begin with an identification of the proper standard of review. Defendants are appealing an order of summary judgment granted by the trial court and affirmed by the Court of Appeals. Our standard of review of an appeal from summary judgment is de novo. Such judgment is appropriate only when the record shows that there is no genuine issue as to the material fact and that any party is entitled to judgment as a matter of law. In reviewing an order for summary judgment, we view presented evidence in the light most favorable to the non-moving party. Finally, we review matters of statutory interpretation de novo. This case presents a question of statutory interpretation of first impression before the court. It is undisputed plaintiff traces interest in 7 lots within country colony to root titles that go back at least 30 years and without reference to nuisance covenants. Resolution of the instant case hinges on the proper interpretation of one of the Act's exceptions. Subsection 47B3 establishes that such marketable record title shall not affect or extinguish the following rights. Covenants applicable. Okay, so this is the specific exception. Here we go. Covenants applicable to a general or uniform scheme of development which restrict the property to residential use only, provided said covenants are otherwise enforceable. The accepted covenant may restrict the property to multifamily or single-family residential use or simply to residential use. Restricted covenants other than those mentioned herein, which limit the property to residential use, are not accepted from the provisions of Chapter 47B. Pretty lit. So, okay, anyways, I feel much clearer on that. So basically, that all would have been thrown out if there wasn't this one specific exception, is what I am hearing. I don't know, again, not an attorney. So basically, recorded restrictions are not the same as enforceable restriction. And that's an important differentiation because just because there even is something doesn't mean it's necessarily enforceable. One of the important things I wanted to also call out here. So because of this, this is not a slam dunk forever. So Myers Park and Eastover hired a lobbyist to try to change state law and reimpose deed restrictions after the Auger case. There are a number of neighborhoods looking at how to impose deed restrictions on a neighborhood or reimpose them if they were there and had previously expired. It's a little bit under the radar. Neighborhoods don't like to signal to developers that their neighborhood might be right to build triplexes in. You have that going on, and at the same time, you have a couple of other neighborhoods. You have Myers Park and Eastover, we've reported, that have hired a lobbyist to try to change state law or to reimpose some of the deed restrictions. If there are deed restrictions on a house that prohibit duplexes or triplexes, that sort of supersedes the city's new development rules in a sort of way to prevent some of the higher density developments going into the neighborhoods, but not entirely, as we've seen. I want to find the story for this. List of surveys. We're just going all over today. Eastland Mall. It no longer exists there. It has been deleted for redevelopment. It is about to be Eastland Yards. Charlottetown Mall, 1961. Very cool. That is really cool. Planning for Eastland started in 1969. The project was developed by Masson Faison, Weatherspoon Realty Company, and the New L Development Company, a family partnership. Charlottean C. Morris Newell. Newell, a 1949 Davidson College graduate, founded the Morris Investment Company in 1955, developing his family's property in Union and Mecklenburg counties. Interesting. I can get so lost in all this, but we're going to try to stay on topic because I got to wrap this up here shortly. So after the residents sued, they did Aspen City Homes, won out with the Lansdowne lot, and filed for 3 units, or proceeded with 3 units. I wonder if there's, let's see if we can just find the actual property, because I'm curious to see what the actual property. Let me pull this back up. Lansdowne. I'm trying to figure out where this is. Is this it? Last sold in 2023, but it says here this was settled December 24. So maybe it's not that one, but it really looks like that one. Could be that one. Where is this? South Charlotte, yeah. Lansdowne. Terms never reported. If anyone, the court file is public, so I'd have to look up the actual. The takeaway here is that whether a specific covenant on a specific lot is alive or dead after the Auger case is a title attorney's call, not mine. Don't trust YouTube video. Don't trust anybody that is not a title attorney or real estate attorney to make that judgment call. But what I am telling you is that before some of this stuff was contested, it was just absolutely like you were screwed if you found any sort of covenants, codes, or restrictions. Now, again, the codes are up, so the covenants and the restrictions are being tested. Many of the restrictions are failing, and covenants, if left unenforced, at some point also expire. And so if you've got a lot that you're interested in and you want to know whether or not it might be able to clear these 3 filters, I'd be happy to chat with you, walk you through it, connect you with a great attorney as well, and try to get you some answers. You can, oh, that's the wrong one here. You can reach out anytime, call, text, or WhatsApp. Or if you are looking for a lot and you haven't found one yet, I also help with that too. So we can help you either way. But to continue on, so now that you have an idea of what lots actually would be legal to, or could qualify to be able to utilize the UDO, we're going to real quick look at the math on this to see where does the land actually pencil out and make sense for this. And actually, I have to leave for my showing for a potential UDO deal. So I'm going to actually pause things here. We can come back to this later. Again, I guess not moving. If you're investing soon, call, text, or WhatsApp. I believe the QR code will take you to where you can book some time on my calendar. Best thing to do though is just text or call. Very responsive. And if you are looking for a short list of areas that might fit what you're looking for your investment thesis, you can take the Charlotte Areas quiz, find the areas that match what you're looking for, scan the code, or the link is also below. I know this is a long one, a little bit slower one. If you made it this far, just know that I love you, appreciate you sticking around. And if you got any questions about this or anything else, drop them down in the comments. I read every single one and respond. My name is Lucas Roller, your favorite realtor here in the beautiful Queen City. And as always, until next time, hope to help you invest in Charlotte, make Charlotte home, and help other people make Charlotte home. Talk soon.